clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas in this honorable court.
We're ready to hear argument. In 1936, Landry's against the Animal Legal Defense Fund from Harris County and the 14th Court of Appeals District.
May it please the court, Mr. Street will present argument for petitioners. Mr. Smalla will present argument for the amicus. Mr. Street will open with the first 5 minutes and will present the rebuttal.
May it please the court. This TCPA case presents an opportunity to align Texas law with the undisputed national consensus that the judicial proceedings privilege and attorney immunity do not provide an absolute shield for defamatory statements given to the media or others unconnected to the judicial proceedings. I'd like to begin with the privilege and immunity questions that were central to the Court of Appeals analysis, but I hope to save a couple minutes for the sanctions issues at the end. As you can see behind tabs B and C in our bench book, it's undisputed that the traditional common law rule, 25 states, the restatement, and all of the leading treatises draw the line that Landry's advocates here. This limit on immunity applies to attorneys and parties alike. In fact, more than half of the cases reflected behind tab B in our bench book involve attorney statements to the media that were held not to be protected by the privilege. And that rule makes good sense. If attorneys were to enjoy some additional immunity beyond that of parties, the parties could simply outsource their defamatory media statements to their attorneys, thereby evading all of the limits on the judicial proceeding privilege. But the same result obtains if this court independently assesses the question under the attorney immunity test that this court has applied in other contexts. This court held in Canty Hanger at page 482 that attorney conduct is actionable if it, quote, does not involve the provision of legal services. This court gave the example of assaulting opposing counsel during trial. Why should the result be any different when the attorney or party verbally assaults or defames the opposing party in a media statement or press conference? This court also said in Canty Hanger that attorney immunity applies to conduct that, quote, requires the office, professional training, and skill of an attorney. Public relations work and social media postings do not require that unique training and skill. And that is why courts outside of Texas hold that press conferences and public relations are not lawyerly work. And a few examples of that are behind tab E in our bench book.
So, Mr. Street, what is your response to their argument that within the realm of public interest legal services, that this is part of the provision of those services? What's your response to that?
Well, our response is that this privilege and the attorney immunity protects the practice of law, not the practice of litigation in the court of public opinion. And I'm well aware of the fact that for public interest lawyers, winning in the court of public opinion is often equally, if not more important than winning in the court of law. But this privilege protects litigation. It protects practices in the court of law. It protects conduct that is part of an attorney's training and skill. And this example is no different than the example this court gave in Canty Hanger of assaulting an opposing counsel. The attorney may well have thought that was a good idea. That was part of serving his client's practices. Just as going to lunch maybe and discussing strategy, driving to the courthouse may also be part of something that an attorney often does in his type of practice. But those are not conduct, that is not conduct protected by the attorney immunity privilege. And
does it matter if the lawyer instigated the disclosure of the information? So in other words, assume the lawyer has just finished a huge hearing and is walking out of the courthouse to her car, and a member of the media approaches her with a microphone, puts it in her face, and demands a comment. If she replies to that request at that moment without having initiated it, is she acting as a lawyer?
I don't think that would change the result on whether the person was acting as a lawyer or not, because it needs to be a communication that is functionally tied in some way to the litigation process. It has to be to a person that's connected to the litigation process, or it has to in some way progress the litigation of the case to be covered by the national consensus rule. And to be covered by the attorney immunity rule, it has to be something that is part of the legal skill and training, and it doesn't really matter under that test who initiates it. Now, I would say that in this instance, these were calculated. These were admittedly things that were done to advance the cause in the court of public opinion. So the court, if it has qualms about that scenario, would not need to reach it in this particular case. In our view, the attorney immunity privilege should not be extended to activities that could be done equally by a PR professional or a marketing professional. That would be to unmoor the privilege from the purposes of according immunity to attorneys.
Mr. Street. Go ahead.
Is attorney immunity waived if the attorney publicly repeats what is filed in a pleading that he or she files in court? Are you saying that publicly repeating that or repeating that to the media waives the privilege and it no longer attaches?
Yes, Your Honor. Attorney immunity or the judicial proceedings privilege, which we think is the better way to conceive of this in the context of statements to the media, would not apply to out-of-court statements that repeat the allegations in the complaint. That's the national consensus rule of the cases behind tab B in our bench book. Nearly half of those involve a republication or restatement of the pleadings in a press conference. And the reason
in Canny Hanger, wasn't the allegation that the attorney falsified a bill of sale? And of course, anybody can prepare a bill of sale. And the question was the attorney acting in the representative capacity at that point? So are you saying that the rule is if anyone can say it, immunity doesn't attach? Because that doesn't seem consistent with Canny Hanger.
No, that is not our test, Your Honor. And I think Canny Hanger very carefully tied immunity to the fact that this was not just any old bill of sale. This was a bill of sale that was prepared to effectuate a divorce decree, a court order. And this court said that the attorney was being charged with using his legal skills to shift the tax liability as part of effectuating that divorce decree. So that case was very carefully limited to the litigation or adjacent to litigation context. Our test is that it has to be exactly what Canny Hanger says. It has to be legal services. This is the practice of public relations and marketing and not the practice of law. And if I could briefly turn to sanctions for a second, if there are no other questions on judicial immunity or privilege. On the sanctions award should be reversed and rendered with no more than nominal sanctions because there's no record evidence that deterrence was needed for Landry's, and thus there is no statutory basis for anything more than nominal sanctions under the plain text of the TCPA. That text can be seen behind tab F of our bench book, and it says that the court may award sanctions, quote, as the court determines sufficient to deter the party who brought the legal action from bringing similar actions. Under the trans-American principles that apply to sanctions awards, we would need record evidence that that type of deterrence was needed, and we would need some sort of record-based showing or analysis that the record-setting six-figure sanction award here was no more than the amount necessary to remedy that deterrent interest.
Wouldn't the correct thing to happen here if you were to prevail on the attorney immunity matter to remand on the anti-SLAPP issues?
We think the court could do that, but the other side's position is that there should be sanctions in any event because there was a legal action, a cause of action that was dismissed, even if there were a remand on the privilege. So we think the court should go ahead and reach the sanctions issue and hold that on this record, no matter what happens with the other issues, no more than nominal sanctions are appropriate. And that's because it's undisputed that on this record, there is no evidence that Landry's had filed SLAPP suits like this in the past, despite enduring years of criticism of the Tiger exhibit. And there's no evidence that it threatened to sue or intended to sue a similar case in the future. The alternative argued for by the ALDF would be an unbounded regime that would allow six-figure sanctions based merely on bringing an ultimately meritless, determined to be meritless suit, and prejudicial arguments about the party's wealth. That would be a punitive regime, not the deterrence-based regime set forth in the statutory text of the TCPA, and it would also be inconsistent with due process principles that require careful tailoring of the award to the statutory harm at issue. Thank you.
If I can just follow up very quickly and make sure I understood your answer. Assuming that we agree, and I'm going to set aside sanctions for the moment. Assuming we agree with you on judicial immunity and attorney, judicial proceedings privilege and attorney immunity, are you saying we should remand this to the Court of Appeals to determine whether the plaintiffs established a prima facie case of their claims, or we should send it back to the trial court for the trial court to make that determination anew?
Your Honor, our position is that the record is established here and that the remand could appropriately be to the Court of Appeals to assess whether the plaintiffs made out a prima facie case on defamation as well as on their business disparagement and tortious interference claims.
Any other questions? Thank you, Mr. Street. Dean Smolla, we'll hear from you.
Good morning, Your Honors. Thank you for the opportunity to appear as amicus.
We're not able to see you, Dean. We saw you earlier.
There we go.
Yep.
Sorry about that. Well, good morning again, Your Honors, and thank you for the opportunity to address the court. I urge the court to adopt a bright line rule. And the bright line rule is you get absolute immunity if you are speaking in connection with a judicial proceeding. And so if it's functionally related to the proceeding, there is that absolute immunity. But once you venture outside that, you lose your absolute immunity. You still have a plethora of other defenses that might apply when you speak to the public about a pending case, but not the strong medicine of absolute immunity. And to address the questions that a number of the justices have asked, this is a peculiar situation in which it is essential that the two doctrines be in perfect alignment. And so if you decide that the animating principles behind the judicial proceedings privilege shouldn't apply to a press conference, shouldn't apply to a press release, then to hold that, to keep the integrity of that division, which is the traditional national position, you can't allow the attorney immunity doctrine to swallow it up. And both sides have perfectly sound arguments as to whether speaking to the press is or is not part of a lawyer's job. But you can cut through that. And you don't have to decide all the situations in which the immunity doctrine would apply or all the situations in which the proceedings privilege would apply. You can simply say the thing that it does not apply to. And you can say, when you're speaking to the press, even if the microphone is put in front of your face as you walk out the courtroom door, you don't have absolute immunity. You have everything else. You have substantial truth. You have opinion. You have actual malice if it's a public case. And I think, as you've already heard, it's critical to remember why we have this absolute privilege. It's not a defamation doctrine that is there to protect freedom of speech. Many doctrines do that, but not this one. This is there to protect the tribunal. This is there to say, when you're in court or you're dealing with matters in court, you will never be hailed into court for defamation or other things for the things you say there. And we take the risk that people will defame others in a judicial proceeding because we want those proceedings unencumbered by a future threat of a lawsuit.
So excuse me, so is there a difference between sending the notice letter to a media outlet and sending an independent statement of fact to a media outlet?
Your Honor, I think the bright line rule should be that whether it's a complaint or a notice letter or anything that is functionally part of the proceeding, the letter itself receives absolute immunity. But once you start sending it out, you forfeit the absolute immunity and you fall back on all the other defenses that might be available.
So
Now,
you're
Your Honor,
saying that the notice letter would not have the protection if you sent it to a media outlet, right?
correct. And that may seem thin. Clearly, the rationale there is at its weakest because you can say, well, the paper can just go retrieve the complaint or the notice letter itself. And so what's the point? But the point is to explain to lawyers what's in the absolute privilege and what's not, and to make it clean. But typically, Your Honor, a case doesn't get brought just because the complaint is posted online or something like that. It's when there's the press conference. It's when there's the press release, because the natural impulse of the lawyer is to spin it and engage in advocacy, and that's when you have the threat of defamation liability. I pointed out a parallel in the letter that I submitted to the court that I think is very useful. It's the most important absolute immunity we have in the United States, one could argue, the absolute immunity under the speech or debate clause. And there the Supreme Court said a senator speaking in the Senate has absolute immunity, but when the senator engages in a press release or a press conference, even if it's an exact repetition, we don't apply absolute immunity anymore. Now you fall back on the other doctrines. I can see that there may be some questions, so I should probably. If not, let me reemphasize that alignment issue. That if you don't, it's clear the two doctrines cover somewhat different things. And I know there's been discussion of the Canty ruling. But if you don't put them in alignment, then you in effect invite parties to do what they otherwise could not do by saying to the lawyer, you go out and you say everything and be our megaphone. And that puts a big hole in the judicial proceedings privilege and a big hole in the law of defamation.
Any other questions? Thank you, Dean. We'll hear from the respondents.
May it please the court. When the Texas legislature passed the TCPA as a bulwark against lawsuits in retaliation for free speech, even they could not have thought of a better example than this one. In response to the defendant's exercise of their free speech rights, plaintiffs threw the book at them, bringing frivolous claim after frivolous claim, such as theft when they still owned the Tigers, abuse of process before there had been any, trespass when there wasn't any, and a request to enjoin future free speech that this court had already held was inappropriate as a matter of constitutional law. Thankfully, plaintiffs have dropped those frivolous claims, but the claims that they advanced to this court are no less baseless. Plaintiffs have zero evidence of causation. They have zero evidence that a single lost prospective customer ever heard a single word that our defendant said. Plaintiffs have no evidence of damages, not a single penny of lost profit, no evidence of actual malice. They asked the court to change the burden of proof, to shift it from the plaintiffs to the defendants, and then have the audacity to ask the court to hold the defendants aren't allowed to defend themselves in TCPA claims. And the vast majority of the defendant's speech was undisputedly true, or non-actionable opinion, or a mere legal allegation that was not verifiably false at the time. On top of that,
Mr. Clinton, if we could get back to the attorney immunity aspect of this, how is having a press conference or talking to the media part of the rendition of legal services, which was the crux of Canty Hanger?
Well, Canty Hanger said the test in Canty Hanger was not the rendition, that you had to, it had to be only something that an attorney could do. The test in Canty Hanger was the same test in Canty Hanger, Youngkin versus Hines, and Bethel versus Quilling. And this is what the court said. And an attorney is immune from liability to non-clients for conduct within the scope of his representation of his clients, which this undisputedly was. Put different, and then the court says, put differently, an attorney may be liable to non-clients only for conduct outside the scope of his representation, which this undisputedly was not, or conduct that is foreign to the duties of an attorney. It did not say that an attorney's skills were necessary. It used the word foreign to the duties of an attorney.
But the facts of Canny Hanger were such that the creation of that bill of sale or the production of that bill of sale was part of the ancillary documents that were connected to the divorce. That was I was the author of that opinion. That was a very crucial part of that decision. And so how is a press conference analogous to that?
Well, I mean, with respect to Canny Hanger, I completely agree that was the thing that the opinion of the court held, and the dissent, as you are well aware, disagreed and said that it wasn't part of litigation; it was just ancillary.
But that doesn't matter because that was not the majority.
Right. No, that's absolutely right. But I think in the court's question, you agreed it was kind of ancillary to. It was after the litigation was over. And the accusation there was not that the rendition of legal services was somehow false or faulty. It was that they put the wrong name as the seller. They falsified the bill of sale. And it doesn't take a lawyer to put the wrong name as the seller and a seller of an airplane, which was there. But in addition to that, I think the court's asking, what is the functional role of pre-suit publicity? And there is a functional role of pre-suit publicity in public interest case. And that is identifying and locating witnesses, identifying and locating additional parties. In cases involving public interest, it can be to secure funding, which they argue that we were somehow in bad faith for securing funding for the litigation, and also identifying and recruiting amicus briefs. And I want to give the court a very personal example. Just 2 weeks ago, Texas lawyer called both of the lawyers on each side of this case, and they answered the phone. They picked up the phone and answered. And the reason they answered is because it's not conduct foreign to the duties of a lawyer to answer a press call. I did not. And the reason that I did not is if this court holds, as they're asking the court to hold, that I'm subject to liability for speaking to the press about the correctly speaking to the press about my client's arguments in a lawsuit, then I'm the next person to be sued by Landry's and be in suit for 5 years on baseless claims. I want to go back to the elements for a moment because they are before the court. I see Justice Bland, you have a question.
How do you respond to the dean's comments, though, that attorney immunity ought to be narrowed to attorney duties and that we have free speech protections and lots of other protections for publicly debating what's going on in court?
Well, it's not a doctrine in Texas that all of the defenses have to be aligned, that you can only pick one, and if you don't get that one, you don't get any of them. I mean, I think that's kind of an absurd argument. With respect to the attorney immunity doctrine, this court held in Bethel that the act of dismantling a trailer was subject to attorney immunity. The act of dismantling a trailer, was it part of litigation? Yes, it was adjacent to litigation. I think that was the word that the plaintiff's counsel used in this case. It was litigation adjacent. So was this. It had a very functional role. Just because one defense doesn't cover you doesn't mean another. And I think it's really important that they didn't put a chart of attorney immunity in that binder. The reason they didn't put a chart of attorney immunity is because it's a uniquely Texas doctrine. None of the arguments that Dean Smalla puts in his brief would back attorney immunity. In fact, he says all these parade of horribles would happen if the court doesn't reverse the lower courts all across Texas who have held this. All these parade of horribles would have happened. Well, they already would have happened. They would have already happened if this parade of horribles was to happen, but they didn't. There are two cases that the courts of appeals have held that attorney immunity doctrine would defeat these lawsuits, both in Highland Capital and in Your Honor's, I think it was Alpert case, where the court specifically, where the opinion specifically said that there was a claim of disparagement in the business community. Now, and this matters too, and this is why I spoke to Strickland versus Medlin in my brief, in the reply brief. The court is concerned with changing the rules of the game after the behavior is already done. And that's the concern that the court talked about in Medlin. It said it didn't want, if something has been established, if this rule has been established in Texas, we're not going to be the ones that change the rule retroactively to deal with one party's conduct. Instead, we're going to let the legislature do the proactive rule changes in Texas. And I think that matters. Also, if you look to the court's decision in Chu versus Hung, this court said that it didn't want to establish a duty to non-clients that conflicted with and was elevated above the duty to the clients. And again, that's what I faced. And in some ways I could be criticized for not taking the call from Texas Lawyer because I elevated an arguable duty to a non-client, to Landry's, above my duty to my client. But I couldn't take the call because I can't tell my wife that I'm going to be sued for the next 5 years and face hundreds of thousands of dollars in legal fees because of my correct position explaining my client's conduct. And that's the real issue here. Are we going to change the rules after the game to decide to change the winners and the losers? There are, between the two privileges, there are 6 courts of appeals cases that hold that this claim is barred. 6. That established a rule in Texas. And if we are going to change the rules of the game, then we should allow the legislature to do it and not the court. And of course the court can, but it shouldn't. Now I want to speak to causation because causation is before the court. Plaintiffs have appealed the 2 ancillary claims, and the 2 ancillary claims were decided on causation. There's no way to remand the causation issue to the Court of Appeals. It was already decided by the Court of Appeals.
Counsel, could I take you back just a second, back to immunity? Do you agree with the characterization of the other side that your position is that a lawyer has immunity for saying these things to the media, but anybody who's not a lawyer who says the same things, a press agent or some other employee, they don't have immunity?
Under the attorney,
what's the conceivable justification for that kind of a disparity between the 2 identical conduct? One has immunity, one doesn't.
Under the attorney immunity doctrine, it would be the attorney who has it. I don't think there's any argument about that. Under the judicial proceedings privilege, if it is speech that has an arguable functional role, I think that if our plaintiff went and posted on Facebook, I'm looking for witnesses who witnessed what I saw at Landry's, which was 4 endangered tigers inside for 12 years straight, and spending most of that time in a 10 by 10 foot cell. All of those facts would be true. And if she were looking for witnesses, I think that would be absolutely covered by the judicial proceedings privilege because it would meet the test. The test for the judicial proceedings privilege is that this is what the court wrote in Shell versus Ritt with respect to pre-suit statements. It said the rule applies when the communication has some relation to a proceeding, which this undisputedly does, and that the proceeding is actually contemplated in good faith and under serious consideration, which it undisputedly does. We meet the rule as it exists today. I mean, that's the biggest problem that we have.
So your position is that a non-lawyer press agent or another employee of ALDF or whoever who's not a lawyer would be protected by the judicial proceedings privilege for engaging in the communications that are at issue in this case?
I'm not sure. Those aren't the facts of the case. So I'm just being honest, I haven't really thought through an employee of ALDF. The facts of this case are that it was the speech of the attorneys and essentially the law firm, which is ALDF. So I haven't thought about whether a non-lawyer employee would have the same privilege. But certainly the party who is at issue, if they were looking for witnesses, yes, I do believe that it would be covered because it meets the test, which is communication having some relation to the proceeding and that is actually contemplated in good faith. I mean, I guess
what my question is sort of what I'm trying to get at is what is the justification in your mind for providing immunity to a particular category of people, lawyers, for behavior for which everyone else is not immune?
Well, I mean, with respect to the attorney immunity doctrine, it is what it is. I mean, that's the court's doctrine, and we're relying on it, and it squarely fits within the court's doctrine as the court has stated it. It is the duty of lawyers, and I guess I would go to Chu versus Hong, this is what the court said there. Imposing a second duty to non-clients would inevitably conflict with the duty that attorneys have to clients. I would also speak to, highlight the Court of Appeals decision, and I think it was the Russell case, which said that an attorney must seek discovery of evidence, interrogate potential witnesses, and resort to ingenious methods to obtain evidence. And it may take going to the press to get witnesses. If you're having trouble getting witnesses, that may be what it takes to do that. Also, it's this free speech issue. Whether they like it or not, the Texas Disciplinary Rule of Professional Conduct 3.07 recognize that there are vital social interests for attorneys speaking to the press on litigation of public concern, which this was. Now, maybe we would have those issues of, horrible defamation in private interest cases, where it's not a public issue, not a public concern that's already going to be in the press. The Dallas Court of Appeals also spoke to the fact that this litigation and all of these issues would have already been in the press because it was an issue of public concern. The press would have picked it up, they would have run with it. And I really think that goes to the causation argument, which is before the court. The Court of Appeals held that they did not have causation. And so that matters. So if with the court's permission, I'd really like to address it. This court has said that causation requires a direct causal connection between the defendant's actions and the injury suffered, a direct causal connection. With respect to defamation, the court said that the injury must be connected to the defamatory statements, the ones that they alleged were defamatory. They agree, they essentially concede in their reply brief that they do not have evidence that any of their 2 lost prospective customers ever heard a word that our defendant said. Causation is before the court, and they effectively concede that they don't have evidence of causation. Now, what they asked the court to do is infer temporal proximity equating to causation. That is a logical fallacy that this court has already called out. In Guevara versus Farrer, which we cited in our response brief, and they did not even deal with in their reply brief, this court said that evidence of one event closely following the other is no evidence that the second was caused by the first, is no evidence. This is what the court says. It raises a suspicion of causation, but this is a direct quote, but suspicion has not been and is not legally sufficient to support a finding of causation. Their causation argument is bunk. It's nonsense. This court has already expressly—
Mr. Clinton, going back to the immunity question, you said that it's the role of the legislature to make decisions, and the legislature has a privilege in Chapter 73 of the Civil Practice and Remedies Code for newspaper accounts of judicial proceedings that are fair, true, and impartial. Are you advocating for an expansion of that privilege beyond what the legislature has afforded for newspaper accounts?
No, and I think that's a great point, Justice Bland, which is the legislature, when it decided it needed to overrule the courts of appeals and the court's opinions on an issue, adopted a statute to do so. And this rule that the judicial proceedings privilege and the attorney immunity doctrine immunize this behavior has been the rule that the legislature didn't overrule. So the legislature, when it saw that it needed to overrule the judicial opinions, did so in the statute. Here, they did not do so because the rule was what it was. There was no need to. And that again goes to, it's a little bit of legislative acquiescence. The legislature has essentially said, we've got no problem with this court's opinions on with the Texas court's opinions on attorney immunity and judicial proceedings. And again, it goes to the duty question, because in Strickland, this court said, we're not going to change the duties without the legislature telling us to. And here, this court said in Chu versus Hong, they don't want to impose a duty on non-clients or on attorneys with respect to non-clients that interferes with the duties that they have to their clients. Again, that's me not being able to answer the phone because my duty to myself and my wife and my kids ended up being greater than my duty to my clients. I wish I could have taken that call and spun the article in the way that they did in their favor, but I couldn't take the call because I can't subject myself to 5 years, multi-hundreds of thousands of dollars, 3 international law firms for an at most $20,000 claim, at most $20,000 claim. That's what we're here. The attorney's fees are probably 50 times what the claim was. If that's not evidence of a slap, I don't know what is. In addition, they have no evidence of causation, no evidence of actual malice, no evidence of falsity of the claim. Let's talk, if I can, I'd really like to talk about actual malice too, because this goes to the core of the First Amendment. This court has said that in an issue on public speech, they have to have evidence of actual malice. You can't get past door 1 without evidence of actual malice. They have no evidence of actual malice. They say that we did not disprove their argument that the attorneys didn't consider the Animal Welfare Act reports. They have no evidence that we didn't consider the Animal Welfare Act reports. They just say it. They have no evidence that we didn't. And the evidence in the record is to the contrary. The evidence is that Nasse met with them, talked about their credentials, talked about how they passed inspection reports, and did a comprehensive legal research, did comprehensive expert research, and she, in good faith, concluded she believed and still believes to this day that they violated the Endangered Species Act. This court in WFAA versus Macklemore and also in Huckabee versus Time Warner said that in and of itself defeats actual malice. If you meet with the other side, conduct research, do an investigation, conclude that and believe that you're speaking the truth, that defeats actual malice as a matter of law. They want to switch the burden of proof, and they had the audacity to say that we're not allowed to defend ourselves. That too was expressly rejected by this court in Adams versus Starside, where the court said that under section 27.006A, it provides that when considering a TCPA motion to dismiss, the court shall consider the pleadings and supporting and opposing evidence. Their argument was expressly rejected by this court. If I could briefly get to the sanctions, I think this is critically important. First, their argument is the evidence is legally insufficient. This court rejected that in Lowe, plain and simple. It said that if you have some evidence of the sanctions award, then it's more than legally sufficient. Here, there is some evidence which this court said you start with the attorney's fees. That's the monetary guidepost that the court uses. So there's some evidence of it. There's also the multiple frivolous claims. Court of Appeals said they were frivolous on their face, and that was not appealed to this court. That is final. They were frivolous on their face. And so there's frivolousness of the claims, and there is the monetary guidepost of the attorney's fees. Second, this court in Nasse versus Texas Children's Hospital, Justice Guzman opinion on page 371, expressly rejected their argument. Expressly. She called it out and said it's wrong. This is what she said. A court obviously need not consider prior sanctionable conduct in calibrating a sanction award for a first-time litigant, for the self-evident reason that no such conduct exists. There is no duty to factor in a factor for which there is no evidence. This court called their argument obviously wrong. They're saying that we must have proven that there was no evidence of prior bad conduct and no evidence of bad faith. If there's no evidence, this court called that opinion obviously wrong, the argument obviously wrong. Finally, in both Nasse and Lowe, there was a request for findings of fact and conclusions of law, which there wasn't here. They cannot say one way or another whether there was what the trial court did or didn't consider because they didn't bother to ask for findings of fact and conclusions of law. And this court said in Lemons versus EMW Manufacturing that the failure to request findings of fact means that we presume the trial court made all the findings necessary to support the judgment. If there is some evidence to support the judgment, it must stand, and only that evidence most favorable to the issue is to be considered. They failed to request findings of fact and conclusions of law, and thus waived any challenge to the decisions or what factors the trial court considered. Thank you, Your Honor.
Any other questions? Thank you, Mr. Clinton. Mr. Street, I believe you have 5 minutes.
Thank you, Your Honor. We believe that attorney immunity and the judicial proceedings privilege are not coextensive in all circumstances. Obviously, attorney immunity applies to circumstances outside of the judicial proceedings privilege, like examining evidence, like entering into a settlement, like effectuating a divorce decree. But in this context, statements to the press, statements unconnected to the judicial proceeding, the privileges should be coextensive for the reasons given by Dean Smalla. To hold otherwise would not only disrupt the national consensus, it would provide an easy means for circumvention of the judicial proceedings privilege.
And so,
Now,
Mr. Straight, what is your response to his argument that was done to as part of the discovery process because it was difficult to find witnesses and that kind of thing?
That argument was never made below. It was not made in this court. And in fact, if you look at the statements themselves and all the arguments made, they are simply restating and expounding upon the allegations that are made in the notice letter. They have nothing to do with gathering evidence. They have nothing to do with gathering witnesses. And I think it's telling that Mr. Clinton recognized he had to now come up with some functional link between those statements and the judicial process. But the cases that have held statements related to evidence gathering or related to witness recruitment to be covered by immunity, those statements on their face were targeted at those purposes. The people that they were spoken to had access to potential witnesses or had access to evidence. And so that is not at all what we have here, where we just have blasts out to the media and blasts on social media. The test should be that the communication must be to some person who is connected in some way to the litigation, as in Shell versus Ritt, a communication with the agency that would be prosecuting the action, or it must be functionally connected in some way, not just in some subject matter way, but connected in some way to progressing the litigation in court. Again, Shell being a great example of that, because the prosecutor had to determine whether to bring the case against Shell.
So, Mr. Street, if Mr. Clinton had taken the Texas lawyer's phone call last week, would his statements have been protected under your articulation of either doctrine?
If Mr. Clinton spoke to the press about this case, his statements would not be protected by absolute immunity, either under the attorney immunity or the judicial proceedings privilege. But there's no parade of horribles to be worried about here. That's the rule that applies in California, Florida, Pennsylvania, New York. It's the rule that's applied under the common law since 1871. It's the rule under the restatement reporter's note that says press conferences by attorneys about their cases are not privileged. But as Dean Smolla points out, Mr. Clinton would be able to fall back on a host of other privileges, qualified privileges. He could say, I'm just reporting the truth of what I've alleged. He would have other arguments that he could make. So there's no reason to be worried about that. What the court should be worried about is unmooring the judicial proceedings privilege from its purpose. When an attorney makes statements in court or functionally connected to the litigation, he or she is subject to the constraints that apply in court. He's subject to perjury. He's subject to sanctions for frivolous statements. He's ultimately subject to the resolution of a neutral fact finder. But when an attorney goes outside of that context and speaks to the press or other people unconnected to the proceedings, under ALDF's rule, there are no constraints whatsoever. Certainly none of those court constraints apply. And under ALDF's rule, there would be no potential for defamation liability. As Justice Lerman said, in Canty Hanger, the crux of that holding was legal services, the provision of legal services. This has no tie to any legal services other than the fact that they wanted to try their case in the court of public opinion. They could have hired a marketing department or a public relations firm to do that. All of the points that Mr. Clinton raises about damages and the causes of action, probably the most efficient thing to do is to let the Court of Appeals address that in the first instance. It assumed that we had met those. Justice Jewell found that we had met those. And this is a defamation per se case. We don't need to prove general damages. General damages are presumed because Landry's was accused of committing criminal activity, even though these individuals knew that Landry's complied with all of the relevant accrediting organizations that determine whether animals are being held in healthful conditions. So we ask the court to reverse.
Any other questions? Thank you, Mr. Street. The case is submitted and the court will take a brief recess.